still on the upholding of governorship elections, and of course the governors there given praises for their efforts. It has been a very busy day at the Nigeria Supreme Court with as many as 8 governorship election disputes billed for the top court's final ruling. As it is, there has been little or no surprises with the outcomes, with the justices affirming the elections of almost all those returned elected during last year's elections, including governors of Lagos, Bauchi, Plateau, and Ebonyi states. It was, however, the court's interpretation and ruling on the Kano State case that attracted wider interest, perhaps owing to the sheer depth of political underpinning that had trailed it as well. Now, Arise analyst Dr. Sam Amadi joins us now for a chat on today's developments at the Supreme Court. Many thanks for joining us, Mr. Amadi, Doctor, rather. So, what are your thoughts? Were you expecting this orgy of verdicts, as it were?
I think, yeah, thank you for having me. Largely, many of them, yes, we expected. I mean, Lagos, Bauchi, Ebonyi, a couple of those places were almost like open and close. But Kano and Plateau were a little bit disturbing because you have the Court of Appeal remove those governors. So, and of course, the volatility, the political fallout. So, a kind of suspension here. Would the Supreme Court confirm the Court of Appeal, or would the Supreme Court reverse them, especially also in the case of Plateau? So, yeah, a bit of worry about how it will go. And it seems to me now, having read snippets of those decisions, that today the Supreme Court got everything right, not just the outcome, I mean, which helped to diffuse the tension, especially in places like Kano, where if it went the other way around, maybe there could be some events. But in the rationale, in the Kano case, for example, the Supreme Court rightly, and we've said that, looked at the evidence and said, look, the Court of Appeal did not evaluate it properly. It didn't, there's no evidence to show that those unmarked ballots were should be to detriment of the governor. And again, the question my view has always been that the jurisprudential standpoint for electoral cases should be that the will of the people, the electorate, should be always respected. The only instance where that should not be done is where it is clear that the votes were either not properly counted. So if INEC did not mark the ballot box properly, 2 reasons. One, you shouldn't resolve it against the candidates. People went to vote for a particular candidate. You have to show that actually that is not the ballot that was voted for. But if it's the ballot that was voted for, then you cannot discount them. And the Supreme Court rightly, put them back. And once that is done, it's very clear that an NNPP candidate won that election square and simple. Plateau, a bit of confusion here. The Supreme Court says, look, we have said that nomination is the responsibility of party, namely the National Working Committee of the party. Therefore, we don't want people to come up and try to determine after the election who is the nominee. And again, I mean, why should this other person from another party come and challenge it? So the Supreme Court says, you know what? Go back to our position that the party decides the candidate. I have a little bit of worry about that. I mean, I totally agree with the Supreme Court, and that's been my view, that all form of certification for election, whether in terms of qualification, in terms of proper nomination, should happen before the votes. Once votes have happened, those candidates should not, for any reason, be disqualified except they didn't win the vote, or in the rare case that they are not even Nigerian citizens. So the Supreme Court restates and say, look, this is pre-election, and this is not even your jurisdiction to determine whether he was properly elected. So if you remove that argument, then there's no other basis. The only tragedy here is that senators have been removed on this now discredited judicial position. So what happens to those guys who didn't have access to come to the Supreme Court to let the Supreme Court restate what is evident? So those Court of Appeal errors are fatal errors. And I would argue, in the interest of justice, maybe the Court of Appeal should go back and revisit those cases because they were per incuriam. They are wrongly entered in the context of what the Supreme Court has now restated magisterially, that
No,
you
Dr.
cannot,
Sam Amadi,
on the basis of...
Dr. Amadi, I'm going to ask you to pause for a bit, so that we can bring you an update from Ebonyi State, where the Supreme Court has upheld the appeal court decision affirming the election of Francis Wuru as governor of Ebonyi State. The Apex Court dismissed the appeal of Chukwuma Odi for lacking in merit, as it has failed to establish non-compliance. Here's Governor Francis Wuru addressing journalists after the verdict of the court.
Let me first and foremost thank God Almighty for a day like this, and thank my legal team and the All Progressive Congress and the President of the Federal Republic of Nigeria. But especially, let me thank the courts for delivering justice to the people of Ebonyi State. I am very grateful to the courts.
Dr. Sam Amadi is still here with us. Dr. Amadi, tensions had been high, especially in Kano State, where it seemed at a point that the APC might actually have a chance at unsitting the governor. So I'm wondering, how would you assess the performance of the judiciary as a whole in determining the outcome of the governorship election? Would you say their performance has been above board?
This round of cases at the Supreme Court has been clearly meritorious in the way they have handled it. Again, they have taken safe options. I mean, to be cynical, to say maybe the Supreme Court look, the safest bet here is to restore these governors. I mean, the governor of Kano, the public opinion is actually against the decision against the governor of Kano State, because it didn't show that he didn't win the election. It's just that the ballot papers were not properly marked and therefore discounted. So it's safe, politically safe to go that way. Don't forget that the Supreme Court is also a policy court. And so the Supreme Court, I might interpret to say the Supreme Court took a position that, look, except we see something really, really explosive, we're just going to return all these guys. And in Lagos State, for example, the Supreme Court was right again. If you look at Section 82, of the Constitution, that talks about multiple citizenship, the caveat is that if you are a natural-born citizen, or the other citizenship is where you are a natural-born, then the disqualification doesn't apply. And the Supreme Court rightly also said, look, you just can't do this. I think the big lesson here, or the big proposition here is, look, we should not take out people who have been validly declared winners of the election. If it doesn't pertain to votes cast, their validity, who won, miscounting, discounted votes illegally, then it shouldn't go and tackle people, after they've won the election and say, oh, they didn't have this certificate. And we can learn from what's going on in the US, for example. Certification disputes should be litigated before vote. Today, several states are saying, or a few states are saying, Trump can be on the ballot. The Supreme Court of the U.S. will determine that question, whether it should be on the ballot on the basis of conviction or allegation of insurrection. That is pre-election. So we should now return our judicial calendar so that people, or electoral calendar, you can litigate whether he's a citizen, whether he was properly nominated. But once they have crossed that point and people have voted, you shouldn't remove them. So the Supreme Court, all these decisions confirm whether deliberately or otherwise, or coincidentally or accidentally, that the Supreme Court restored all those whom INEC have declared as validly elected, and those whose electoral challenge does not border much on the votes, but border on maybe a qualification, citizenship, like in Lagos, the unmarked ballot in Kano, improper primary in Plateau. The same with Ebonyi, where the governor is said to have been a PDP member, didn't properly resign before he went to. Those, if you look at it, those issues are extraneous to the votes. So it's a lesson now that we have to find a way to solve those issues. I don't agree with the Supreme Court totally that it doesn't matter how a candidate emerges. Even though the party decides, if the party breaks its rules in deciding who is a candidate, it's a justiciable issue. And the Supreme Court can say, this is the proper candidate. But those should happen before votes. Once a candidate has been certified by INEC and there's no judicial decertification of that candidate, and the votes happen, then the Supreme Court should only, or any other court for that matter, should only disqualify those candidates or nullify the election on the basis of votes, not on the basis of pre-qualification, which ought to have happened at the administrative stage of INEC and the judicial review process before votes. So these results today are intelligent. They are well thought out. Like I said in my tweet that the Supreme Court is final and must be obeyed. But it's not final because it's always wise. Sometimes the Supreme Court gets it terribly wrong. I mean, the case of Imo State is a typical example in 2020. But today, the Supreme Court got the right results, politically safe results, but at the same time, jurisprudentially sound and acceptable argument. So it's not just that they got right and saved us from possible social crisis, but they also had the right reasoning to justify the decisions they took today. So I agree with the Supreme Court, and I think today they passed the test very well.
Very good, Dr. Amadi. But can we make a case for the Electoral Petition Tribunal? How effective are they, especially where the Supreme Court has the final word, and especially when it comes to contentious electoral cases? I'd like your thoughts on that.
I think the tribunals, first, there's the lack of coherence in electoral decisions. I mean, if you watch the different Court of Appeals, they seem to come at different parts. Now, one example, like I put the Plateau State, PDP lost almost, I think, all the senators. They won all the House of Reps on this bad idea that the State Working Committee that signed off their nomination, where there was a dispute, there was a court order about the State Working Committee, and then it was supposed to be NWC. And INEC accepted these nominations, and the people voted for them, and you vacated all these people. That's irresponsible, and that's bad jurisprudence. So today, we can say that the Court of Appeal is in disarray. There's need for streamlining. They should follow precedent. So there should be clarity on what the Supreme Court has decided, so that if there is also lack of clarity, this is very important, they can make a reference to the Supreme Court to decide legal question, so that they can now implement it. The notion that different Court of Appeal will validate or invalidate results of election on a principle that the Supreme Court later discounts in a very serious way, frown at. I say, you guys ought to have known. That doesn't speak well about the Court of Appeal. So I think there's a level of contradiction, incoherence, and maybe lack of rigor in some of those cases that went to the Court of Appeal. And that's why you see in these 6 or 7 cases we had today, about 3 of them or 4 were reversal of Court of Appeal's decision. And it's not good. The Supreme Court should often defer to the Court of Appeal. So there's something really wrong in the way the justice of the justice of the Court of Appeal applied these principles. And we will hope that after this electoral cycle, there should be clarity as to the questions that are critical. For example, nomination, pre-election and post-election matters. So that we know what the courts will now apply, so that we don't have where different panels apply different things, and then maybe the governors are very, very lucky that their cases get to the Supreme Court. Now, imagine if they terminated at the Court of Appeal. It means that the governor of Kano, the governor of Plateau would go home today, and then because of a poor decision. So there's so much risk that we need to clarify judicial rulings and jurisprudence of the court. And I think this is one area that I think the President of the Court of Appeal should also find a way to look at it. It's not good to have different outcomes in different courts for different candidates at the Court of Appeal. So I would say that the tribunals have not done very well. They failed largely in some of these cases. The Supreme Court in this last group of cases did very well. And it means that we should, and the logic here flowing from this is that we should be less disruptive of election results and defer to INEC, defer to trial courts, but then deferring to INEC should mean that we have to totally revamp INEC. So INEC conducts re-regulatory adjudication, meaning that certification should be what INEC should decide in a much more administrative, quasi-judicial manner. And there should be judicial review of those decisions INEC make before election, so that by the time candidates are certified, they are certified. You can't go back to question their emergence, except for something as big as they were not Nigerian citizens at all, in which case the Supreme Court can't say you can't bring someone who's a Nigerian citizen to be governor. Otherwise, issues around whether they had a good primary should have been settled before election. So some of these are the takeaways. We should now reform our processes so that we don't have this misalignment between the Court of Appeal and the Supreme Court in many cases. It's tragic. I think the Supreme Court and the Court of Appeal should look at what do we do to those plateau senators, House of Reps members who lost their seat on a very wrong judicial opinion. The judges were wrong, dead wrong, as the Supreme Court has confirmed. In all the over 6 cases, only the governor got saved because he went to Supreme Court. But these other guys are out of the place. Lalong is going to be senator on a very wrong, he didn't win election on the principle that the other guy was wrongly nominated. In the same process that the governor, who will remain a governor, was nominated. There's something fundamentally unjust about it. And I think there should be a way in which the Court of Appeal should go back and revisit those wrong decisions they have made in the case of senators and House of Rep members in Plateau State.
Very well said, Dr. Amadi. A bit of breaking news now. Alex Oti of Abia State. The Supreme Court has affirmed the election of Alex Oti of Abia State as the duly elected governor of the state. Now, Dr. Amadi, my next question is, a number of governors, while reacting to their... Well, I understand that the Supreme Court has also affirmed the election, of the governor of Cross River. He is the duly elected governor of the state. Now, a number of governors, while reacting to their ruling, Dr. Amadi, this is for you. They have thanked the President, Bola Ahmed Tinubu, for not interfering, in the judicial process. So I'm wondering, what does this say about, number 1, the President, number 2, the judiciary, and number 3, our electoral process?
I think that the Supreme Court, the Chief Justice should issue a strong reprimand to these governors. I mean, that statement suggests that this is a political decision. And like I've analyzed, the law, the logic favors each of these decisions. So this Nigerian servitude, I mean, I've argued before that we seem not to be happy to run a democracy. We are looking for elected kingship. So the president is a king, and whatever happens to us, all good fortunes, we thank the president first. So what is presupposed that the president's magnanimity, self-forbearance, and self-restraint, otherwise, he could have asked the Supreme Court justices to flip it to his party AP. So for not doing that, all hell, Mr. President, this is nonsense. And again, it speaks to the lack of intelligence of these governors, social intelligence, emotional intelligence. I mean, how can you go to a contested case in the Court of Appeal, the Supreme Court, and the law justice of the Supreme Court take their time, make argument, write paper, and you thank the president? That's nonsense. So I think it's really sad. It's an indictment, it's an abuse of the Supreme Court, their independence, their ability. This is their terrain. We have 3 branches of government. In fact, Mr. President himself is a benefactor of the Supreme Court's wisdom or whatever for saving his own job. So how come you are thanking the president? So I think it speaks to the notion that even though we're a democracy, the real values driving our governance interaction is authoritarian notion that the guy who has the sword, the president who has the commander-in-chief of the armed forces, if he doesn't want it to happen, it won't happen. So if I got a judgment at the Supreme Court, it's because the president did not want to push. If he wanted to push, he could get me out. It doesn't speak to judicial independence. And it's, even though it might be a misspeak, but really defines where we are today as a people. We've not accepted the rule of law. The rule of law is the right of judges to make mistakes. It doesn't mean that judges get it right all the time, but we know that we believe that the judges decide what they want to decide. They don't decide it because somebody tells them to do that. So the theory of judicial craft is that judges may err, but they err autonomously. They err because they are applying their mind and got it wrong. They don't err because they are programmed to achieve someone's own strategic interest. So what these governors have done is they have rubbished their good fortune. The real work the Supreme Court has done to give them justice, they are attributing it to political forbearance or political prerogative or political goodwill of a president who himself has no role to play in the determination of disputes, electoral disputes. So it's sad. It speaks of lack of proper understanding of judicial process. And it speaks to the temperament that's not democratic, the temperament that a sovereignty considers everything it does as predicated to what the president likes or doesn't like. And that's why you don't see the kind of, and by the way, this president, when he was governor, fought hard, fought strong, courageous against the federal government. He didn't go to Obasanjo, kowtowing or bowing or expressing delight. He stood his ground as governor. Let these governors stay where they are. They're elected by the people. They shouldn't be seen that their governance should rest on some kind of sweetheart deal or romance with the president. You are a governor, my friend. Stay there and do your work. Stop all this confusion of saying, oh, thank Mr. President for what? He's not part of this deal. This is court. And whether they got it right or wrong, the court got it right or wrong. And so today, we salute the judges for doing a good job, being very thorough, look at the evidence in Kano very painstakingly, restating the principle in the case of Plateau and all these cases, and even in Lagos. So we say, kudos to the judiciary for living up to this position, and not thank you to Mr. President, not at all.
And on that final note, I'd like to thank you, Dr. Sam Amadi, for your thoughts on those issues. Good to have you with us on Newsday.